is extracts from the Another defense is that extracts from the parliamentary reports. For instance, you've taken in information from the parliamentary reports, which was stating maybe the issue of PPI or any other relevant information. So it is a good defense for you to say that this is an extract from the parliamentary reports. But how may you be allowed for you to succeed in that defense? Number one, you must show that you must give a copy of the extract or an abstract of the parliamentary reports, and also there must be an affidavit which shows that in fact this information or this copy was from a parliamentary report. And another defense that you can adduce very well is copies of parliamentary copies of parliamentary reports. The other one was extract from parliamentary reports, but this one is copies of parliamentary reports. So according to Section 10 of the Defamation Act, it provides that it shall be a defense for the defendant that the information that has been published was parliamentary report and should adduce the copies of the report with a supporting affidavit and the correctness of such copy. Affidavit, to my people, maybe if you're not in a legal profession, means it's something like a certificate which clearly indicates that whatever you are bringing to the court is a matter of truth and there is no false in it. And the sixth defense is an intentional defamation. And that one is accorded under Section 13 of the Defamation Act laws of Kenya. That provides that it shall be a defense against the action for libel if the defendant can prove that he acted innocently. Sometimes maybe you are publishing an information, but you are innocent. You did not know that this information could refer to the plaintiff, and you did not know that this information could lower the reputation of the plaintiff. So if you are able to show that ground very well, and you did not have any malice aforethought, you will succeed. But however, you must, if you make that offer to the plaintiff who claims that that information was defamatory, and the plaintiff therefore accepts that offer to amend that information, then no proceeding again will proceed before the court. But however, if the plaintiff doesn't agree for the offer for the amendment of that publication as per Section 13 of the Defamation Act, that information by the plaintiff, if you will continue to publish that information, will be used as a defense by the plaintiff that you refuse to amend that information. So having closed all the defenses which I have stated, may I state the remedies which can be given to this person who has violated who is liable for defamatory statement. So number one is general compensatory damages. So remember that in the case of Martha Karua, as I discussed before, in this particular case, there was a defamatory statement. And because there was a defamatory statement, the court awarded 30 million shillings to compensate for the damages in which the defendant had caused. Yeah. And so another provision is aggravated compensatory damages. So these are aimed at compensating the aggrieved where the accused has acted in an unjustified or in an improper way, which intensify the injury or grievances. For instance, let's say you are a publisher in a newspaper and you publish an information which was indeed defamatory. And further to that, it is quite clear, maybe the plaintiff told you that that information is defamatory information, and you continued to publish that information and adding even more facts, which will be more injurious to the plaintiff. So it means that the court, now having established all of the circumstances which have been presented to it, may award aggravated compensatory damages to the plaintiff. And another one is injunction relief. So for instance, let's say a defamatory information was published to the media, and let's say maybe by Citizen TV or any other a TV channel, and that information, because it has not been removed from the website database, that information can be viewed by any person at any time. That it can lead to, let's say, multiple publishing. So it's position of the United Kingdom for quite a while that a person whose information was published in the website would bring an action for the continuous publication of that information. If another person sees that information or feels that information, now it raises a different action in defamation. And so, like in that case of sorry, let me take you back to that case of sorry, I'm nearly there. Yeah, sorry. Okay. In that case of Royal Media Services Limited versus Valentine Makuro Maina and another. So in this particular case, the plaintiffs were relying on that position whereby that information had been displayed, had been published on the media database, and it continued to be published for quite a while. And so they were relying on the UK provision. But in this particular case, the court found out that the UK provision had been abolished and it was not applicable anymore. But in this particular case, the court saw the information and the circumstances of the case, and they therefore decided that they will allow the suit for defamation. So remember that under Kenyan position, there is no that provision for multiple publication, but however, it is up to the discretion of the court to allow for that information, for that action to be taken as defamatory. I'm sorry, I'm quite tired, and I think I don't have any other provision unless maybe anyone among us has any question with regard to defamation. Thank you so much. Angela, may I close this, Nini, because of some disadvantages around here?
So she has done a good job. She has elaborated the whole situation about defamation, the elements that have to be met, the elements that have to be satisfied for defamation to be satisfied, to be said that defamation has taken place. And she's also gone through the defenses. I don't intend to keep you long because this is even way past our ending time. So if there are any questions and anyone can be able to answer any questions concerning the presentation, I think I'll be in a position to answer, or anyone can assist me. So anyone with a question or an addition to what has been presented today, please use the reactions button to lift up your hand, then I'll allow you to speak. Thank you. Anyone with a question, concern? She's talked about the defenses, and this is particularly so for those at Kenya School of Law. There's a unit known as legal writing and drafting. So I think this is a leakage. So we are as Sharia Clinic, we are very strategic on who we bring and why we bring them. So, and the topics we choose. So we've been very strategic. So for those at KSL, I think this will be a walkover for you. Yes, Natasha?
Good evening.
Good evening, Natasha.
Mine is not a question, but rather a clarification. And while the presenter was presenting, I noticed that she mentioned that the limitation of action provides that you can bring an action within 3 years for defamation. I would just like to correct that and mention that the actual timeline is actually 12 months, which is 1 year. That is all.
Yes, you're right. Now I can see your back. Karibu sana. So I hope you're able to listen in. So thank you, Natasha. Yes, the law says I think it's section, what section is it? It talks about the 12 months, which is 1 year. So 1 year for defamation cases. Thank you, Natasha. Anyone with a question or an addition to what Nehema has presented? Maybe Nehema, I have a question for you since you're back. It's good you're back. So what happens when someone is in the public space, a public figure, leave alone the parliamentarians, and right now we have people known as digital influencers, we have celebrities. So what is the place of the law when it comes to defamation in that regard? Are celebrities catered for? And then as you answer that, I think you've talked about the freedom of expression. We also have the freedom of the media. To what extent are those rights limited? Because we all know they are not absolute rights. They can be limited at some point. So to what extent will you have crossed my boundary and now committed a defamation? And then my last question, since this thing is going on YouTube and we are not just speaking to lawyers or advocates or trainee advocates, we're also speaking to the general public. So how would you advise the Wanjiku down there, anyone who's going to watch this, the layperson, I mean someone who hasn't studied law, how would you advise them on their rights and how to protect themselves against lawsuits concerning defamation, even as we enter the election period? Because maybe, it's a very touchy subject, and we don't want people being sued for defamation. So how would please address those questions? Thank you.
Okay. Thank you so much, Angela Achieng, and thank you. Who was her? Natasha Selepwa. Sorry for that information. Defamation is for 12 months, which is appropriated to 1 year. Sorry for that information. And to your question, Angela Achieng, I would like to address in this position that under Article 33 of the Constitution, it's quite clear that everyone is entitled to right to freedom of expression. You have the right to seek, you have the right to impart any knowledge. But however, remember that under Article 24 of the Constitution of Kenya clearly provides that our right to some other rights can be limited. But however, the limitation should be based on justification and reasonableness. And now the court would have to look at the circumstances of the case. For instance, if the words are defamatory, and to what extent is it lowering the reputation of the person who is affected? So even if that person is a public figure, there is a certain way in which the public or the society appreciates that person. For instance, let me call just A. If A is a singer, he is a public figure, and we know his songs very well. And if another person publishes an information so as to lower his reputation, so that the society will be influenced by that publication of the information, his reputation will of course be lowered. And if it is lowered, then that person is entitled to maybe to an injunction as one of the remedy, or even compensation. And what I will say to the general public, maybe not for the legal profession, is that we have to take care when we exercise the freedom of expression. Know that there are some of the limitations in which the freedom of expression can be curtailed, and we should be cautious to what we expose in social media, even in Facebook, with regard to any other person. Sometimes, we are ignorant and we are arrogant with the way we just display an information, but we don't know that that person may take an initiative of suing you before the court of law. So, yeah, that is it.
Thank you. You answered my questions. Maybe the last question would be, what if, yes, you've mentioned all the elements, that yes, it has to be a false matter, it has to be
Yes.
defamatory, it must refer to the plaintiff.